Abdul Kul Bazun Capital Attack Padana but Mafu Hadi Station Unicorn. Anuki fi and I should call Wakula Shikalu. Na at the Kun Shikalu. Anuki Ferragun Shikalu Wakalu Ferragushi. Anuki Wahid Bakalu Wakalu Wahid Man. Look Aikilu Angie came out Ferragun Shikalu Wakama Faid. Aikilu Aquenu could look of things that came out Wukamaka Father Kalu the Amy. Anuki Kaba Hawa. Kalu Kalun Kalu Yakun Keki. Kalu Babu together. Ken all peers thinking some G's for found every all. I am in the level all levels. You're all in all. I am a part of all and all is a part of me. I am one with all and all is one with me. I can succeed as a part of all and fail as an individual. I can be all I wish in all as long as my wish is to stay in all. I am never alone. All is I am. All can I can. All does I can.
All right, Romana family, we got another Let's Talk the case, Malachi York with Jabari Jaheem. I'd like to welcome you back for another round of this. So.
Yeah. Well, first of all, I want to thank you, Brother Abraham, for giving me another opportunity to appear on your show and to speak with your guests. As you well know, being the son of Dr. Malachi York, I'm quite sure you know all the trials and tribulations that have been throughout this trial. This trial is reeking with conspiracies all over the place. We just have to really point those conspiracies out, and it's not what we think, what we feel, it's what we know. And the facts support what we know. Last time I was on your show, I had stated or attempted to state the ramifications or the contents and ramifications of Adrian Patrick's motion for a new trial that was subsequently thrown out by the new attorney representing Dr. York, and that was attorney Jonathan Marks. At the new trial hearing, and I'm going to lay a little foundation before I read this motion, because I also would like to read Jonathan Marks' motion after Adrian Patrick's motion to give context to what was done on August 13, 2004. But before I go into that, I would like to read something that came out of several things I want to read. Number one, the letter that I wrote to Dr. York last year. I'm not going to go into the whole context of the letter, but what I will do is to go into the part where I was referencing Judge Rawls and a quote that was made by the Supreme Court in dealing with prosecutorial and judicial immunity. And the court went on to say, when a judge acts intentionally and knowingly to deprive a person of his constitutional rights, he exercises no discretion or individual judgment. He acts no longer as a judge, but as a, quote, minister, end quote, of his own prejudice. Now, that quote in and of itself lays out the foundation of how this judge, Judge Ashley C. Rawls, acted out throughout this whole trial of Dr. Malachi York. There was several instances where you can clearly see, even if you didn't know anything about the law or the application of the language of the law or how to apply the law, the average lay person would see and conclude that the judge was wrong. When you're talking about going on the website as the judge is conducting the trial of the Nawabian website and claiming at the trial that he looked at that website late in the night, you can conclude that the judge was going beyond being a judge. He was going as being a minister of his own prejudice, because the judge was telling you that he was conducting a surveillance on the defendant and his tribe while he was conducting the trial.
Sure. I'm sorry for cutting it.
Go ahead, bro.
What kind of surveillance are you talking about? The judges was conducting. What made, what was the most obvious thing that showed that within the court that says that was it he actually stated that? Or
Yeah, he actually stated that. That's on record. Well, we all can agree that the judge never presented himself as an operative of the CIA or a private investigator. And as a judge, he showed, when he gave a rationale in his docket 447 redacted order, when he brought in the fact that he was surveilling the website, and he also admitted that the Nawabians and what they were saying as to his family heritage going against Yamasee tribes, he did say that was correct. Okay, so the judge was not here to personally go on the website doing an open court and monitor the proceedings that was happening on the Nawabian website, even though the Nawabian website was pretty much articulating what they felt the judge was all about. And you got to keep in mind that they had a good reason to be outraged, because that same judge who got on the case after the former judge, Judge Lawson, recused himself around July, that same judge, Judge Ashley Raw, a year ago, was appointed by the Bush administration to become a federal judge. But what people don't understand, that same federal judge who was appointed a year before Dr. York got arrested was also an attorney that was representing a Coney hospital against Dr. York's wife family. So, and this same judge as an attorney had lost the case for millions of dollars. So the moment that a judge had stepped to the bench, someone was supposed to approach that judge, all right, and because the judicial canons allows for that, to tell the judge, based on his former past as an attorney who was against the York family, that judge should have stepped down and recused himself from the case.
Okay, so question, was any of Dr. York's attorney aware of the past of this particular judge with Dr. York, with their client, the master teacher?
Well, I don't have no evidence to show that any of the judges or the attorneys knew about the judge's past, but there's a wealth of information from Dr. York's office, as well as followers, as well as the family of Dr. York, to have given those lawyers an indication of what they will not stand for in reference to this judge. Okay. So apparently you can reasonably conclude that the followers, as well as Dr. York, as well as his wife's personal family, which is Dr. York's family, knew something bad was coming down the tubes in this case, and that was a reasonable suspicion, which fanned out later on.
Oh yeah, and would it be like for the judge himself to actually notify or actually made mention of that before he even stood up there as a judge, like there's some type of discrepancy or bias within for him to even stand as a judge, or it's not even illegal for him to do that?
Well, that's a good question, brother, because I remember some time ago, I was in a courtroom, a criminal courtroom, and I heard this young lady who used to be an employee of Walmart, and when she went to the judge and the judge found out on the bench that she was an employee of Walmart, the judge declared in open court that he had to recuse himself. And the reason why that judge recused himself is because the judge had stock in Walmart. So when you look at the judicial canons that the judges are bound by, even in the judicial canons, they said that the judge, even the appearance of being questioned concerning something that others may have an issue with as far as this judge standing on the bench, that in itself is powerful enough for the judge to recuse himself. In Dr. York's case, Judge Lawson saw that when he recused himself after Dr. York's plea was rejected. He recused himself. But this attorney, C. Ashley Royal, was silent throughout the whole trial, which he shouldn't have been silent, because obviously no one would reasonably expect that a judge who was an attorney involved in the case dealing with one of the family members, which Dr. York was, no one would believe that judge, who was a lawyer who had lost the case, would be reasonably delighted that he had lost the case, okay? And now, all right, he's going to give and dispense justice as a judge. That is very much should have been questionable when that judge started out the gate. But unfortunately, it wasn't, and it only became an issue 5 years later on a writ of habeas corpus that was done by those representing Dr. York. It's an ethical issue that you have to be a judge with integrity in order to meet the standard of what any judge in that kind of situation, based on the judicial canons that they are guided by.
Cool. Well, I have a question. Are you aware, or do you know of any like legal loopholes that would make that would permit him to do that, or you know what I mean? Or is it like totally, like you say, unethical, and it should have been brought to someone's attention? Or was it a thing that because he may know some little loophole that he was able to get away with?
Well, to tell you the truth, the only loophole that that judge could have taken advantage of was the loophole of some of other people who had a right to question him being silent about the situation. That in itself presents an issue of a loophole. Sure. As far as the standard that when I read about the judges being a judge, a difference between being a judge and a minister of your own prejudice, clearly outlines what this judge is all about. And you're going to see this when I read Attorney Adrian Patrick's motion for a new trial that was subsequently thrown out the window by this new attorney. You're going to see that not only did the judge was cited as far as a shout out to the judge in open court to recuse himself twice, he was also told by the same attorney and that same attorney had asked for a mistrial. So the motion for new trial really it's a highlight, okay, of what went on in that courtroom. All right, anytime you got a judge, all right, where during the trial that was represented by counsel, he allowed and entertained pro se filings on behalf of Dr. York, and he was just bringing them in. But when the right filing came before him, then he started hollering about hybrid representation, and that he was not going to allow any more hybrid representation. That means that Dr. York cannot be his own attorney and have an attorney on the case. While he have an attorney on the case, he allowed, after he made that order, he allowed over 40-something filings to go before his court, where he adjudicated those filings. And the key document that you should look at to see what I'm talking about would be docket 447, the judge's redacted order. That order was voluminous of a lot of issues that judge, that was thrown at that judge, by the filers of that motion. The problem was they filed it in the wrong court where they should have filed it in 11th Circuit. They filed it to him. And when they filed it to him, he exercised no jurisdiction because he didn't have no jurisdiction because the writ of habeas corpus was a successive writ. And anytime you put a successive writ before a district court, you have to send it not to the district court. You have to send that writ to the 11th Circuit Court so that they can give the district court permission to hear what you're complaining about.
All right.
In this case, it was not filed properly. It was filed improperly, and the judge seized on that to give a determination on issues that he had no jurisdiction to terminate.
Okay. Okay. So we got a hand up.
Sure. This brother Mason, I'm just wondering because I'm listening to everything, but why wasn't it a motion to suppress evidence filed immediately when he was incarcerated to stop the whole process of them being able to do any of this? I'm like not even an attorney, but I've had my own cases that I've beat because I filed that one motion, a motion to suppress evidence. So I'm wondering why didn't they do all? Why wasn't his like the legal like it's inadequate all the way around? I know that. File a motion to suppress evidence as soon as you get locked up. So they ain't got nothing else but what they got on the table to try to charge you with. All this other everything everybody talking about wouldn't even exist if they had to file a motion to suppress evidence. Sure.
Okay, well, the answer to your question is twofold, okay? Number one, there have been numerous motions in limine to suppress evidence. They did that.
No more fairy tales.
But that don't stop the train, okay, from going forward. What stops the train from going forward is when your attorney cite and raise the issue of lack of subject matter jurisdiction, which attorney Ed Garland had raised. If you go to Dr.York's detention hearing for a bond, that's exactly what Ed Garland had raised. And he raised that question after he had asked Jolene Ward, who was an FBI agent, at that time. She was on the stand, and he asked her, do you have any witnesses? When you say any witnesses, that means not only your accusers, but also those who got government immunity grants, and any other witnesses that may be hostile against you. He had asked her, do you have any witnesses that can say that the purpose for traveling across the interstate was for sexual activity? Jolene Ward said no. That right there raised a jurisdictional issue as far as the court and the federal government having proper jurisdiction to make any decision on this case. Because as it is said, and as it is a maxim of law, that jurisdiction once raised cannot be waived, nor can it be forfeited. So if you raise jurisdiction, then you would expect the next step to be is to argue the jurisdiction. So when you're talking about jurisdiction, it's not like something that you can put aside and say, I'm gonna deal with this later. Because what you're doing, the reason why they're saying it can't be waived is because the issue of jurisdiction is germane to a court's power to decide a controversy, to decide a case. If it don't have no jurisdiction, it has no power. That's like, your wife is in the operation room and she's about to have a baby, and the doctor went out for coffee, and all of a sudden the janitor comes in and he wants to deliver the child. The janitor has no jurisdiction nor authority to deliver a child. Well, it's the same thing with a judge who has no jurisdiction. They can't move forward on the presumption that, hey, Ed, we're going to do this thing tomorrow, but right now we're gonna go forward and do our thing. That's not what subject matter jurisdiction or lack of subject matter jurisdiction is all about. It can't be forfeited. It cannot be waived. And subject matter jurisdiction can be raised at any time during the process. So if there are any more questions, I want to complete what I wanted to do the other week, 2 weeks ago, and that was to bring Attorney Patrick's new trial motion before your audience and actually read what this attorney had to contend with and dealing with a judge who was biased and prejudiced against his client.
All right, let's hear it.
All right. Now, before Adrian had left or he was terminated, he had put in 2 motions. He put in a motion for new trial. He also put in a motion for a judgment for an acquittal, which by statute, he had to do within 7 days. He could not have delivered a motion within 7 days on the strength that he needed to show in that motion. He had to do a general motion, but he reserved his right to come back and strengthen those motions later on during the trial process, because the time to hear these motions was at the new trial hearing, which Adrian was not a part of. Now, Adrian says in his motion here, pursuant to Federal Rule of Criminal Procedure, Rule 33B2, comes now defendant Malachi Z. York by and through his attorney of record and moves the court to set aside the guilty verdicts and forfeiture verdicts returned herein on January 23rd, 2004, and grant a new trial. In support of this motion for new trial, the defendant shows the following. 1, that on January 23rd, 2004, a federal grand jury returned a guilty verdict on all counts except count 8, and the jury returned a forfeiture verdict against the defendant in case number. 2, that the defendant should be acquitted and discharged due to the government's failure to prove guilt beyond a reasonable doubt. 3, that the court committed several errors of law warranting a new trial. A, here's the errors. The court improperly participated in the case by suggesting and prompting the government to introduce certain evidence statements from a medical report on David Noel. The defense counsel performed a thorough cross-examination of witness and alleged victim, David Noel, concerning a prior inconsistent statement in his medical report where he denied that any abuse had occurred. Right after the cross-examination, the court, sua sponte, quote unquote, or on its own proceeded to suggest and prompt the government to introduce certain evidence statements from the above referenced medical report. The defense immediately objected to the court's improper participation in the trial and requested that the judge recuse himself. The court denied the motion and went so far as to say that the court could put the evidence in itself. The defense counsel once again requested that the court recuse itself. This act, plus several other acts committed by the court, demonstrated a clear bias against the defendant by the court and contributed substantially to the guilty verdicts in this case. B, the court did not.
Yeah, can you basically explain that to them a little in layman's terms for those who may not understand a lot of the,
Right. Well, what Adrian is saying here is that the court was actually trying to play the role of a prosecutor. He was blocking Adrian after Adrian had made a strong cross-examination of Tariq Noel in reference to what they tried to get in as his medical evidence. The judge went over Adrian Patrick to try to reference other matters within that report in order to have the government go around the objection that Attorney Patrick was making as to that medical report. Adrian, at that point, asked the court to recuse himself. That means that he's telling the court that you are violating my client. And because you are violating my client, at this time, you should remove yourself from participating in this case. The judge at that point denied Adrian's oral motion that he was actually making to the court.
For what though? For what reason? Hey, I'm just thinking to myself, for what reason? What real reason or legal reason does he have to deny it? What did he say? Why did he say that he denied it? He's denying.
Well, what he said was that he can put the evidence in himself. Okay, which is not only false, but you are going beyond your discretion as a court. What Adrian is telling you that the judge was abusing his discretion. Okay, because if the judge can put in evidence to the jury, then what you need the prosecution for? It's their job to test the evidence or the potential evidence, and it's the judge's job to either admit it or deny admittance to what the government or what the attorney wants to submit to the court as evidence. But the judge saying, hey, I'm gonna do the prosecutor's job. I'm gonna put it in evidence, and I'm not gonna even test it. I'm gonna put it in evidence because that's what I want to do. That's the bottom line. So then Adrian asked him twice to recuse himself because Adrian is an attorney. He's a skilled attorney. He understands the legal ramifications and the applications of the law. He rightfully saw that the judge, and the only basis for what the judge wanted to do was the judge's premise, and that was, I can put in the evidence myself. So the judge is telling Adrian that if you don't allow the government to do it their way, by allowing you to pierce their evidentiary position as far as evidence, as far as submitting that evidence to the court, then I'm going to do it for them. And that was improper.
Right.
The judge cannot act as an attorney, and he also cannot act as a prosecutor. The judge had violated his judicial canons, and that's what Attorney Patrick has sought.
And why he asked him to recuse himself.
Mm-hmm.
Oh, thank you for that. We do got a hand up. Can you make it quick so he don't lose his train of thought as he's going through this? You can unmute. You want me to unmute you? All right, continue.
Okay.
Yeah.
B, the court denied the defendant a right to present a proper defense by denying to allow hearsay evidence under Federal Rules of Evidence, Rule 803, subsection C. This evidence was related to statements made by Dr.York as to his plan, intent, and motive to create the stories about the molestation and to bring down the defendant. This evidence was critical to the defendant's defense and to the jury's proper understanding of the defense. Now, here, Attorney Patrick is trying to establish and try to, because they didn't bring in Jacob and put him on the stand. What Adrian had to do, he had to rely on hearsay evidence as to Jacob's plan. So this is the part where he tried to get Dr.York, who was known at that time as Damian Pryor, to take the stand so that the judge can decide whether what Deuce was talking about as to what Jacob told him, that it can be admitted, or Deuce can be admitted to go before the jury. At that point, they cleared the court of all the jurors, which they had the right to do under the law, and they tested two witnesses that Dr.York had a compulsory right to have in his defense, pursuant to the Sixth Amendment of the Constitution. Now,
so you're saying, basically what you're saying is that that Adrian's argument was, if Jacob York is the one that initiated it, bringing him up, or you really don't have any case. Is that what I'm hearing?
Well, what he's saying is that Jacob York was he was the main principal person that was connected to the FBI, connected to Sheriff Seals, who brought witnesses to the government. And he wanted Damian Pryor to take the stand to tell the jury, who was not in the courtroom, what Jacob York had told him on or about November of 2001. Damian Pryor said that Jacob told him that he is going to take Dr. York down. We're going to take him down. He told him about his role as far as being the facilitator of the FBI. He was on the payroll, and he wanted Damian to be a part of it because he was trying to meet Damian or Duswa in order to get Duswa to forge some documents. And Duswa on the stand was also talking about the orgies that Jacob had and the people who he was trying to recruit. And the judge had stopped Duswa. At first, the judge told Duswa and told Attorney Patrick that he was going to let in Duswa's statement that what Jacob told him as far as Dr. York going down, but he was not going to let the other statements that Duswa was making to come into the jury. All right, because the reason why the judge said that was the judge felt that was before the fact as far as those statements that he was making. So the judge, in essence, was disconnecting the conspiracy aspect from Adrian Patrick's defense.
But that wouldn't have been a strong argument anyway. The court would have known that, right? Because they could have just came up and said that's hearsay with Jacob, right?
Well, yeah, but Adrian was approaching it as a hearsay exception. There are exceptions to the hearsay.
Okay.
Right. And Adrian was approaching it from that angle. All right. And when the judge did not allow, because you had two witnesses, you had Dr. York's daughter, Leah York, and you had Damian Pryor. Now, here's the question: if they had to be introduced as witnesses around the midnight hour, then why wasn't they on the witness list during Ed Garland's tenure as Dr. York's attorney? Because Adrian only been on the case since December 12, 2003. Ed Garland been on the case since the case started.
Abdul cool bazun chapel attack padana but mafu hadi station inukolo. Anuki fi na aishi fikalu wakula shikalu. Na atakuni fikalu. Anuki feragun shikalu wakalu kalu feragun shi. Anuki wahid kakalu wakalu kalu wahid man. Nuk aikilu anji kema feragun shikalu wa kama faid. Nuk aikilu wa kwenu kudiku kwa fi shikalu. Kema yakawu kama kafaji kalu ni emi shikalu. Anuki kaba hawa. Kalu kalu nani. Kalu yakun keki. Kalu babu together. Again, all pairs, speaking some G's for proof, find every all. I am in the level all levels. We are all in all. I am a part of all, and all is a part of me. I am one with all, and all is one with me. I can succeed as a part of all and fail as an individual. I can be all I wish in all as long as my wish is to stay in all. I am never alone. All is I am. All can I can. All does I can.